With your permission, I would like to start the session, sir.
Yes.
Good evening, everyone. I, on behalf of Legal Expatriate, welcome you on the seventh day of our 10-day online course on Art of Drafting Civil and Criminal Matters. It's an honor to introduce our esteemed speaker for today's session, Mr. Nilesh S. Ghanekar, who stands as a celebrated figure within the legal sphere, particularly known for his extraordinary advocacy skills. With a practice that encompasses a wide range of legal matters, he is known for his client focused and ethically grounded approach to the practice of law. As a senior criminal advocate at the Bombay High Court, he carries a legacy of exceptional advocacy that has left an indelible, um, indelible mark in the legal arena. His exceptional ability in cross examine has garnered administration from judicial officers and serves as a wellspring of inspiration for numerous junior lawyers. Mr. Nilish's remarkable career is a testament to his unwavering commitment to the pursuit of justice. His reputation as a prominent lawyer shines through his remarkable advocacy skills, making him a distinguished personality in the legal community. His dedication, expertise, and commendable courtroom performances have earned him a status of a legal legend. We are privileged to have such an accomplished speaker today, and we eagerly anticipate Mr. Nilesh Ghanekar's insights and wisdom. So please join us in giving a warm virtual welcome to our esteemed speaker. But before handing over the session to our speaker, I kindly request all the participants to keep your mic and camera off so that it would not create any hindrance during the ongoing session. Over to you, sir.
Thank you. So the topic which is being there, drafting of a regular bail application and drafting of quashing of FIR, quashing of proceeding. First, we will take drafting of regular bail application. Now, there are various types of bails. The first, anticipatory bail, regular bail. Now, as the topic is drafting of regular bail applications. In regular bail applications, first thing which we have to see that whether the offense for which we have to file bail application, whether that is bailable offense or non-bailable offense. If it is a bailable offense, then we have to file application before the learned magistrate under section 436 of CRPC. For that, if the offense is non-bailable, then there are categories of offenses which are triable by the court of magistrate, which are triable by the court of session. The sentence for which the maximum sentence which is there for the offenses against the accused who is charged. If the offenses are punishable for life or death, then the bail application, if it is not coming under any of the clauses, then we have to file the bail application before the regular bail application, before the court of session. Now, first, while drafting the bail application in bailable offense, we have to mention the name of the court because generally the application is before the learned magistrate. So, before the court of learned magistrate, then the crime number, the sections which are there applicable against, which are added against the accused, and then in the first para we can mention the facts of the case. In the second para we can mention the date on which the accused is arrested. Then in the third para, as the offense is bailable, we are seeking bail by way of right, and therefore we have to mention that the sections which are there against the accused, they are bailable offenses, and therefore he is having a right to be released on bail. And by writing the formal grounds that he will not abscond, he will not tamper the prayer. In application for bailable offense, it is not necessary to write much. Even one-page application is sufficient, as you are seeking bail by way of right. When bail application for non-bailable offenses are there, if the offense, we can file bail application before court of magistrate. The application will be filed under section 437 CRPC. If we have to file bail application before sessions court, that application will be under section 439 of CRPC. In bail application under 437, even while drafting the applications, the body of the application is same. The first, the name of the court before whom we are filing, that it is a court of magistrate. Then the crime number, then the name of the applicant whose bail application you are filing. And then in the subject clause, you can mention that the bail application is filed under section 437 of CRPC in respect of offences punishable under section so and so which are there against the accused, the crime number and the police station in which it is registered. In the para number 1, you can describe the applicant, that who is the applicant. In the second para, you can mention the facts, the allegations which are there in the FIR. That FIR is lodged by who has lodged the FIR, what are the allegations which are there in the FIR. Then after writing the allegations, then in the third para, you can mention that the accused was arrested on which date, he was granted PCR up to which period, on which date he is taken in MCR, and then he is in jail. And after that, you can, whatever the grounds which are available in respect of that offense, those grounds are to be mentioned. And after writing the formal grounds, thereafter the prayer that the criminal application may be allowed and he may be directed to be released on bail in crime number so and so. So this is how the application is being drafted under section 437. In respect of the offenses wherein the sentence of life imprisonment is there, even in those offenses, there is no bar to file application before the court of magistrate. Even in respect of offense under section 326 of IPC, in respect of offense under section 409 of IPC, the maximum sentence which is there, that is provided, that is life. Even in respect of these offenses which are triable by the court of magistrate, we can file application even before the court of magistrate. Even in so far as if under section 437, if the offense is under section 302 of IPC or the section for which the life or death imprisonment is there, in such type of cases, we have to file direct bail applications before the court of session. But if any old aged person is there, if any infirm is there, if a person is suffering from any mental medical problem, in such type of cases, even we can file an application before the court of magistrate. And in that case, we have to mention that the reason for which we are filing the bail application before the court of magistrate, that is coming under the proviso of 437. And as the applicant is lady, she is old aged, she is infirm, medical problems are there. If any baby is there along with her, that is the difficulties. By mentioning such, if your case is coming under that, you can file an application before the court of magistrate also. When there is no such any particular performa which is there, we come across various applications are there filed by various different advocates with different styles. But most important, what is required to be there in the application is the court before whom you are filing that bail application, whether it is a court of magistrate or whether it is a court of session. Then the application number. In some courts, in Aurangabad, it is bail application. In some other places, it is to be styled as miscellaneous criminal application. Somewhere it is criminal bail petition. So whatever is the nature of the bail application at that place, we have to mention it accordingly. Then the name of the applicant, and thereafter we can write down that if your bail application is there under section 439 of CRPC, we can mention in the matter of section 439 of CRPC, and the offenses, if they are 302, 149, 148, 504, then in the matter of section 302 with other offenses of IPC, and then in the matter of crime number so and so registered with so and so police station. And then by writing the names of the applicant or applicants, then the respondent. In some cases, we have to take care while making the respondents. In a case wherein accused is, there are allegations or sections of POCSO Act are there, we have to add the victim or the informant as respondent. Even in cases under Prevention of Atrocities Act, the informant is required to be added as a respondent, and therefore those are required to be mentioned as respond number 2. Respond number 1 is state of Maharashtra, and respond number 2 will be the informant or the victim. In a case under POCSO, or wherein the offense under section 376 or other offenses are there against women, we can't write down the name of the victim, we can't write down the name of the informant or any relation. Even we can write down the name of the mother, father, brother, sister, no one. So a care is to be taken that while making a respondent in respect for POCSO Act, we have to just mention in respondent column as XYZ or ABC, whatever may be. But we can't disclose the name of the victim in the application. Even while writing, even in the body of the bail application, we can't mention the name. Even a case is there that crime is registered on the information given by victim. Just we have to mention victim. No need to, we can't write down the name, so that care is to be taken. If we will fail to make them the party, again your time will, it will take time, because on the date of hearing you will have to add the victim as a party, and then again you will lose days. And therefore care is to be taken that they have to be made a respondents. Even in respect of the, and when we are by drafting the bail application, it is not necessary that each and everything or all the grounds are to be mentioned. The specific grounds, the important grounds, they are to be mentioned in the application. It is if your defense is clear, then you can mention the defense. Otherwise, defense should not be taken at time of the bail application. But in case wherein you are having a right, you are having a defense of alibi, and instructions are given to you that accused on the date and time of incident, he was not there present on the spot, and he was there at some other place for which you are having a documentary evidence or solid evidence. In such type of cases, the plea of alibi is required to be taken at the first possible opportunity. So in such type of cases, care should be taken while taking instruction, while drafting the bail application, that if accused is having any defense which is required to be taken at the first possible opportunity, then that is to be mentioned in your bail application. Otherwise, if subsequently you are going to raise that defense, even that will be objected by the prosecution, that was not taken at the first opportunity, and then possibility of afterthought evidence is there, and therefore to avoid that opportunity to the other side, it is proper to mention your plea of alibi or any specific defense in your application. Even in cases wherein you are having a right to private defense, if cross cases are there, those cross cases are to be mentioned. The FIR which is lodged by you, what is the fact, that is to be mentioned. While drafting the application, you can even give the annexures to the documents and paging, because that will make you very easy to argue the matter at time of the hearing. The first, you are annexing the FIR which is against you, thereafter the FIR which you have filed, then the bail application, if it is you are filing the bail application in High Court, the copy of the order, application and order which is rejected by the Court of Session, and the other documents, those can be annexed subsequently by giving the annexures and paging. So that will make you will be comfortable in arguing the matters, and even the judge will find it easy to understand. even care is to be taken that if any photographs are to be filed in a case of rape or POCSO, wherein you are claiming that there is the relationship is consensual, they were friends, there was love affair. In such type of cases, you should avoid annexing or annexing the photographs along with the application. If you want to rely upon such photographs, you can directly produce those photographs in a envelope directly to the court. So that is to be avoided. No photographs are to be annexed along with the application. Even while drafting the bail application, uh, it is that after writing all the grounds which you have taken, then subsequently you can mention that the other grounds will be taken by you at time of the hearing, and by writing the formal grounds, you can proceed with, you can write down subsequently the prayer that criminal application may be allowed. He should be released on bail, regular bail, whatever anticipatory bail, whatever you are asking, that relief can be sought for. Even there is a provision for interim regular bail, even in such exceptional cases, wherein if you are claiming that the offences for which the accused is arrested, that is a bailable offence, but along with the principal accused, you are arrested and you are detained, and therefore the detention is illegal, unjustified. Even in such type of cases, you can pray for interim regular bail. If you are filing a bail application before the sessions court, you can file a separate application with interim regular bail. And if you are making a prayer before the High Court, you can make a prayer after the main prayer that pending the hearing of bail application, accused may be released on interim regular bail, and with an undertaking in the application that accused will remain present at the time of final hearing. So court, if grants interim regular bail, court may impose a condition that the accused will remain present before the court on the date of final hearing. So if the court finally finds that he is not entitled, court may take him in custody. For example, in a case, we come across cases wherein accused number one, he is charged for offense under section 376 of IPC, and the other family members, they are against them only allegations of section 504, 506, that subsequent to the incident, when the victim went to lodge report, at that time threats were given. So against the other accused, for example, he may be the brother of the principal accused, sister, mother, father, or any relative. We come across that police arrest them as the FIR is registered with all the allegations together, 376, 504, 506, 34 of IPC. And then those accused, they are also detained. They are also given PCR. So in such type of cases, we can file an application seeking interim regular bail, that the other accused, against them only section 504 or 506 is there. Even we come across, even in respect of offense under section 302 of IPC, there are allegations against some co-accused in respect of screening of offense, that he has helped the main accused to screen the offense, he has taken away the weapon, or he has concealed, he has helped the accused to bury the dead body. So against him, the charges are only under section 201. He was never at the place, or he is having no role to play for offense under section 302 of IPC. But with aid of section 201, he is arrested and he is behind bar. So even in such type of cases, an application can be filed that he should be granted interim regular bail, because in fact his arrest and his detention in that case is unjustified and illegal. So that is you can file a interim regular bail application also. Even while drafting regular bail, even bail applications are to be filed if the accused is convicted. After conviction, if the sessions court or the court of magistrate, if he convicts accused, in an application can be filed for suspension of sentence up to filing of the appeal. Because when you will file appeal, you will have to file a separate application for suspension of sentence and bail. This application can only be, you can ask for only suspension of sentence and bail till appeal period. But what are the conditions under which such applications can be filed? The accused should be on bail on the date of judgment. Second, the conviction should be for maximum 3 years. If the conviction is more than 3 years, and if the offense is bailable for which he is convicted, then even application can be filed. So these are the conditions under which an application for suspension of sentence can be filed before the court who has convicted. In such case, while drafting the application, you have to mention the important grounds which are there, that the accused is convicted for which offense, the maximum sentence for which he is convicted, that maximum sentence is up to 3 years or it is less than 3 years. He was on bail throughout trial. He is having high hopes and he is going to file an appeal against the conviction. So these are the necessary grounds which are there, which should be taken in the bail in the application for suspension of sentence and grant of bail. If the sentence is 4 years, 5 years, or more than, then the convicting court, the court who has convicted, that court ceases to have power to suspend the sentence and grant bail. In such case, application for bail, suspension of sentence and bail, that is required to be filed by filing appeal before the appellate court. If a sessions court has convicted, then we have to file appeal before the high court. If the sentence is not life or death, then the application goes before single judge. If the conviction is life or death, then the appeal goes before the division bench. While drafting the application for suspension of sentence in appeal, if the accused is on bail during that period, then you should mention that as the sentence was less than 3 years or up to 3 years, he is on bail. If he is not, then you have to mention first in the first para the accused for which offense he was charged. In the second para, you can mention the facts of the case of prosecution. In that para, you can mention the number of prosecution witnesses who were examined, the defense of the accused, what was the defense of the accused, and then the conviction for the offenses for which he is convicted. And after writing the conviction, then having been aggrieved by the judgment and order of conviction, he is filing the appeal on following amongst other grounds. And in that, along with the application, you can mention the grounds on which you are seeking suspension of sentence. Even if he was on bail throughout trial, that is to be mentioned. If you have paid the fine amount, that is to be mentioned. The grounds on which you are seeking, you are claiming that the conviction is not proper, that is to be, those are to be mentioned. It is not necessary that if you are having hundreds of grounds, it is not necessary to mention 100 grounds in that application. Even all 100 grounds need not be there in the appeal. The main important grounds which are there, those are to be mentioned in the appeal or in the application. And in this way, the application for suspension of sentence in appeal is drafted. Even one more bail is there, wherein that is statutory bail or default bail. When accused is arrested, charge sheet is to be filed against him within 60 days or 90 days. That depends upon the sentence for which the offenses are. If take a case that if accused is against him allegations of section 302 or 376 of IPC are there, then the maximum time for which they are entitled to file charge sheet, the stipulated period, that is 90 days. But if offense is under section 306 of IPC or any other offense for which the sentence is up to 10 years, because up to 10 years, the time prescribed time to file charge sheet is 60 days. More than 10 years, it is 90 days. Therefore, you have to be you have to see that whether the offense for which the accused against him the charges are, those are punishable with 10 years or more than 10 years. In some cases, prosecution or the investigating officer feel take a case because for 306 that the maximum set time is 90 days, therefore they don't file charge sheet within 60 days. You can take a benefit of that. You can file an application for default bill. While drafting default bill, you have to first mention, because it is not necessary, because the facts are not considered in default bill, neither merits are considered. What is considered at time of default bill? It is that when accused was arrested, when the period of 60 days or 90 days got over, the date on which you are filing bill application, whether that is 61st day, 91st day, 92nd day, that. So while drafting this application, first you should mention that accused is arrested with allegations of so and so offense. The sections are to be mentioned. Then second, in the second para, you can mention the maximum sentence which is there for those offenses, whether that is that will be under 60 or 90 for that purpose. For example, if it is under section 306 of IPC, you should mention that for the maximum sentence for offense under section 306 of IPC, it is up to 10 years, and therefore the period for which is required for which the charge sheet is to be filed, that is 60 days. Then in the third para, that he is arrested on so and so date, the date on which you are filing application, that is 61st, 62nd, 63rd day, as the case may be. Till that time, charge sheet is not filed, and as charge sheet is not filed, the applicant accused, he has accrued the right to be released on bail. He is ready to furnish surety, and therefore he should be enlarged on bail. These are the only necessary grounds which are required to be there in the application when accused is seeking default bail or statutory bail. So it is not in that application to mention all in detail all the grounds. When you are asking for default bail, you are asking it by way of right, and therefore it is not a case wherein you are asking the bail by way of discretion of the court. And when you are asking the bail by way of right, these are the only things which are necessary to be written down in the bail application. Even we come across that we are required to file applications after applications. Generally, accused is having a right to file bail application once before the sessions court, before filing of charge sheet during the period of investigation, and second time once in high court before filing of charge sheet. If you don't get success at time of first application for the sessions court or even in high court, then you are filing bail application again after filing of charge sheet with this change of circumstance. Then in all the cases when you are filing a bail application, if it is first, it should be mentioned that this is your first bail application. In case if it is your second or third application, then you have to mention the first bail application, this that it was so and so number that was rejected by which court on which date, and by writing it again when you are filing the second application, you have to mention change of circumstance, because second application or subsequent bail applications are entertained only in a case when there is change of circumstance. So in all the cases wherein you are filing the bail application, second or third, you have to mention that what is the change of circumstance. It is necessary to be mentioned in the application, and it is necessary to be mentioned to disclose in your bail application all the bail applications which were earlier filed. So if it is your fourth bail application, you should mention all the three first previous bail applications. There should be no concealment, because if you will not mention in your bail application, and if the other side will show to the court that they have concealed the fact in the bail application, the previous bail applications, and rejection is not mentioned, that will not be proper. The court will go against you. So in such circumstances, it is necessary whenever you are filing a subsequent bail application, it is necessary to mention the previous bail application numbers, the rejection, the court before whom it is rejected, and then on what ground you are again filing. So if it is after filing of charge sheet, you have to mention that my bail application was rejected on so and so date. After that date, charge sheet came to be filed, investigation was over. If there is any liberty which is granted by the court, you should mention that court has granted liberty to move bail application after 3 months, 6 months, 1 year, and that got over on so and so date, and with that change of circumstance, present application. So this is to be properly mentioned in your application. Take a case that even if you file bail application, if the court rejects your bail application, then the co-accused, he moves an bail application, his bail application is granted. For example, take a case that you are filing bail application for two accused before High Court. Honorable High Court rejects bail application of both. Both are standing up on same footing, allegations against both are same. Only one out of them goes to Honorable Supreme Court. Honorable Supreme Court allows the bail application. And in such circumstance, you are also entitled to be released on bail on the ground of parity. And therefore, while filing the bail application again before the Sessions Court on that ground or before High Court, you should mention that Honorable Supreme Court has granted bail to the co-accused. The applicant stands upon the same footing or better footing, and therefore he is filing this application. So if this is specified, that is proper on your part, that is proper for consideration of your bail application. While drafting bail application, it is also necessary to take proper instructions. If there are no criminal antecedents, then you should mention in your application that there are no criminal antecedents. We come across many cases, many applications wherein without taking instruction, this is written as a by way of a formal ground or copy paste that there are no criminal antecedents. If we are mentioning in application that there are no criminal antecedents, and subsequently at the time of hearing, it comes to the knowledge of the court that there are criminal antecedents. So the statement which you have made in your bail application, that will be a false statement and that will not be proper. Even the court may go against you on that ground that you are misleading the court. And therefore, necessary proper instructions are required to be taken. That if there are no criminal antecedents, write down that there are no criminal antecedents. If there are criminal antecedents, no need to write down anything, and only in case that if the criminal antecedents are such that wherein the accused is acquitted, you can mention that against him previous one offense or two offense were there, but he is acquitted of those offense. Or if you can mention, if you want to mention, you can even mention that those offenses have nothing to do because those offenses are altogether different. Against one accused, there may be cases of gambling act, there may be cases of petty nature. So you can mention, and the main offense is 302 in which you are asking for bail. So those offenses doesn't show that he is that if you are asking bail for a bodily offenses, 326, 307, then whether he is charged for offense under section 324, 325, 326 previously or 307, that will be material. But if those offenses have nothing to do with the present case, you can mention that the previous offenses are different. Just because there are criminal antecedents, bail applications are not rejected. Those can be only taken into consideration if there is any strong evidence against you. If in a case, so therefore, it is always better to take proper instruction and write down, or whatever the cases are there. If you can justify the cases, you should justify it in your application. These are some of the bail applications, regular bail applications, which we file. And now the second point which is there, it is in respect of quashing of FIR, quashing of proceedings. Normally, the quashing of FIR and quashing of proceedings, those are filed under section 482 of CRPC, inherent powers of Honorable High Court. Even we can file quashing of FIR, quashing of proceedings under Article 226 of Constitution of India. The principle, the consideration is same. The consideration for discharge, the consideration for quashing of FIR, the consideration for quashing of proceeding, that is more or less on same footing, same consideration is there. So when you are filing, you have to file an application for quashing of FIR or quashing of proceeding. First, you have to see that whether it is really a case wherein you can file an application for quashing of FIR or quashing of proceeding. Because we come across that no sooner accused gets bail, he comes and say that we will file quashing, because filing application for quashing of FIR, quashing of proceeding, it has become like a fashion that everybody. But it is not that in each and every case we can file application for quashing of FIR or proceeding. That requires an exceptional case. So first thing you have to see that whether the allegations which are there against the accused, the evidence which is there available against the accused, if that is taken as it is, without subtracting or adding anything, we will take those entire thing at its face value. If it constitutes offense, then there is no question, there is no case of filing application for quashing of FIR or quashing of proceeding. If taking the entire allegations as it is, if it is not making out a case against the accused, then it is a case wherein you can move an application or a petition for quashing of the proceedings or quashing of FIR. When we are filing an application prior to filing of charge sheet, it is quashing of FIR. If charge sheet is filed and subsequently we are filing application, then it is quashing of the proceeding. While drafting quashing application, we in the first, because the quashing applications they are filed before Honorable High Court, so in the before Honorable High Court so and so bench, if it is before any bench, then criminal application or criminal writ petition, whatever you want. Then in the after that you have to mention if you are filing a criminal application under 482, then in the matter of section 482 of Code of Criminal Procedure, then the offences for which the accused is the FIR is registered against him or charge sheet is filed. For example, take a case under section 306 of IPC. So in the matter of section 306, 504, 506 of IPC, and then the crime number and the police station. So in the matter of crime registered with so and so police station, crime number so and so. So that is there. Then the name of the applicants, all names should be mentioned. Then respondent, the first respondent is state of Maharashtra. Second respondent is the first informant or the victim. Same analogy applies even that if the victim or the informant is the victim under 376 or POCSO, you should not mention the name, just XYZ. Then by writing the formal grounds, the first para, the description of the accused, that applicant is accused in so and so. In the second para, you can mention the allegations which are there in the FIR, and thereafter whether he was arrested, he was granted anticipatory bail, and thereafter the grounds on which you are asking quashing of the FIR or quashing of proceeding. And subsequently, by writing the formal grounds, thereafter the prayer that criminal application may be allowed or criminal writ petition may be allowed. The proceeding, the FIR registered with so and so for offence under so and so may kindly be quashed and set aside. If you are asking for staying of the proceeding or staying of the investigation, then you can in the prayer you can mention that pending hearing of the application or pending hearing the petition, the investigation should be stayed. You can even make a prayer that till if it is prior to filing of charge sheet, that charge sheet direction should be given not to file charge sheet till disposal of the application. So these are the prayers which you can make it in application for quashing of FIR or quashing of proceeding. When we have to see the first thing which is there, the landmark judgment in a case of Bhajanlal. In Bhajanlal, there are about 7 points. They are not, they are only illustrative. That those are illustrated that in which cases FIR or the proceedings can be quashed. In which cases, in order to stop, to prevent the abuse of process of court, the proceedings are required to be truncated, stopped at that stage. If we see, if we read all those 7, you should be able to make out a case that in which case category of this your case is coming. Your case may be there coming under one category, it may be under 2, or it may be even more. So likewise, you can mention, you can specify in your petition or in your application that your case is such that comes under clause 1, 2, which are being mentioned in a case of Bhajanlal. Those which are illustrated, the judgment of Bhajanlal, it is reported in AIR 1992, Supreme Court, page number 604. It is State of Haryana and others versus Bhajanlal and others. The first illustration which has been given, that where the allegations made in the FIR or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. So that is the main thing, that you have to consider. You take the entire allegations as it is. If after considering the entire allegations, if those allegations are not disclosing the ingredient of the offense, then you can say that we will take this entire allegation. What are the allegations? These are the allegations. Those are not constituting that offense. The ingredients which are required to constitute that offense, they are so and so. This ingredient is absent. And if this ingredient is absent, then this section will not be applicable. And therefore, it's a good case wherein you can file an application for quashing of FIR or quashing of proceeding. Take a case under section 306 of IPC, wherein a person commits suicide, leaving behind a suicidal note that he had taken a loan from so and so person or persons, and they were harassing him. They were asking him to return the amount. They were giving threats to him, and because of them, he has decided to end his life. And by writing a suicidal note, or even nowadays by taking out a video of such, he commits suicide. In such case, we can file an application for quashing of FIR as well as quashing of proceeding on the ground that here the intention of the accused was not that he should go and commit suicide. Even if they have harassed him or they were behind him demanding their money which they have given him on loan. So for offense under section 306 of IPC, mens rea, intention is a necessary ingredient which is absent, and therefore it is not constituting offense of abatement. And if abatement is not there, then in such circumstances there is no reason to proceed with the matter, and therefore the proceeding should be ended here only. And then this comes under this category wherein even if we accept, take a case that we are accepting that he has committed suicide, we are accepting that he had taken loan, even we accept that we were asking him to pay the money, we were even giving threats to him that if he will not give the money back, we will file a complaint against you, we will beat you. So even if all these are there, those were all with intention that he should return back the money. If he will die, nobody is going to give them the money, so they will be the last person to see that he is dead. So in such circumstances, by making out such all grounds, you can file an application for quashing of FIR, or if charge sheet is filed, quashing of proceeding. Then the second ground, the second illustration which is being there, where the allegations in the FIR and other material, if accompanying with FIR, so whatever the evidence is there, they do not disclose a cognizable offense, justifying an investigation by police. Then in such case, you can file an application for quashing of FIR or quashing of proceeding. Even this example was there for 306. Even if second example, if we see, offense is registered under Atrocities Act, Prevention of Atrocities Act, Section 31R, 31S, and along with it, there are other offenses under 504, 506. Threats are being given. Now, in such case, that if we are coming with the case that those abuses which are there, those abuses are not in public view. If FIR is there, that accused called me on my mobile and he gave me threats, he gave me abuses on my caste. So that was not in public view. Take a case, allegations are that accused came at my residence, they entered my house and they abused me. Even if allegations are there that abuses are being given in cabin, abuses are given at any place wherein no else is present, or the persons who are present, they are only the friends or relatives of the victim or the persons to whom the abuses are given. So this is not the requirement of law. The law says that the abuses or the humiliation should be in public view. So if it is not in public view, you can file an application for quashing of FIR, quashing of proceeding on the ground that for both these sections, what is required, that abuses should be in public view, that is absent. And therefore, the other offenses which are there, they are non-cognizable offense for which police, they were not justified in taking cognizance. And therefore, this is a case which is proper case to get it quashed. So this is under the second example, wherein it does not disclose any cognizable offense or the ingredients of the offenses are not there. Then the third, where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense or make out a case against the accused. In second clause, it was that though it may be disclosing a non-cognizable offense, but it is not disclosing a cognizable offense, then also you can move an application for quashing. As for non-cognizable offenses, police, they are not justified in registering the FIR because FIR itself is very clear that that is first information in respect of cognizable offense. If police, they want to investigate a non-cognizable offense, then they are required to obtain permission from the magistrate before proceeding with the investigation. So in such circumstances, the second clause was that it was disclosing a non-cognizable offense. Then also you are justified in filing an application for quashing of proceeding or quashing of FIR. The third clause, it is not disclosing any offense. For example, take a case that FIR is registered for offense under section 420 of IPC. Whatever the allegations are, those are in respect of a commercial transaction. Even if those allegations are taken as it is not disclosing the ingredient of cheating. That ingredient, there is no deception, there is no inducement. So even if we accept the entire allegations as it is, if that is not making out the ingredients of cheating, it is only a civil dispute or a civil transaction which is there in between the party. If it is your case, then on that ground you can move an application for quashing of FIR or quashing of proceeding. Then you can write down in your petition that whatever the allegations are there, those are civil nature. If any civil dispute is there, generally we come across, even there are judgments wherein Honorable Supreme Court has said that we find that only in order to get immediate relief, the people, they file criminal proceedings, FIR. In fact, the proper course is to proceed with a civil proceeding. So if that is your case, you can file an application for quashing of FIR or proceeding. Then fourth, it is where the allegation in the FIR do not constitute a cognizable offense, but constitute only a non-cognizable offense. No investigation is permitted by a police officer. The same which is there, the second clause and fourth clause, they are more or less the same. Then the fifth, where the allegation made in the FIR or the complaint are so absurd and inherently improbable, on the basis of which no prudent person can ever reach a just conclusion, that there is sufficient ground for proceeding against the accused. So, in a case wherein allegations are such that they are unbelievable, they are highly improbable, you can't believe them. In such cases, you can say that these allegations are not making out any case, any substance against the accused. This we come across when you are filing an application for quashing of proceeding FIR in respect of 498 of IPC. In 498 of IPC, they are having strained relation. There is a domestic dispute which is there in between the parties. There is delay in lodging FIR. There are allegations that when we come that allegations are so absurd, improbable. Husband is having a company, he is an industrialist, he is having 4-5 vehicles, and then allegations are there that he has demanded 5 lakhs for purchasing a car. So such type of allegations are so absurd, improbable, then we should mention that this is highly unbelievable, improbable, and these are the cases wherein you can move an application for quashing of FIR, quashing of proceeding, and those are there under the illustration 5. Then 6, where there is an express legal bar engrafted in any of the provision of the code or the concerned act. There are some bars which are there. For example, 195 of CRPC. If any document is fabricated, forged, allegations are there that is being used in any court proceeding. And if you want to bring a case, that is a legal bar under section 195 of CRPC, wherein the complaint should have been filed by only a competent person or the court as per the direction of the court. So if there is specific such bar, then in such case, we can file an application for quashing that there is a specific bar which is there, and therefore the proceeding, it is not proper to proceed with the proceeding. In a case, take for example a case wherein you are filing a quashing of complaint of defamation, wherein your case is that the complainant who has filed the complaint, he is not coming under the definition of aggrieved person, because that complaint can be filed only by aggrieved person. And then there is a legal bar that if cognizance is to be taken, if proceedings are to be initiated, it should be filed by the aggrieved person. And as there is a bar, he is not there, you can file an application for quashing of proceedings in respect of such proceeding. So these are the cases wherein bar is there. If complaint is being filed, accused is a public servant, court has taken cognizance, but there is no sanction. In such case, you can, as there is a legal bar, that court can take cognizance only if there is a previous sanction, or if the sanction is not proper, accorded by a competent authority. Even in such cases, you can file an application for quashing on the ground that either sanction is not there or the sanction is by an incompetent person, and therefore there is no it is not necessary to proceed against the accused, and therefore the proceedings should be quashed. So that is under, if there is any legal bar, such applications can be filed. Then 7, where a criminal proceeding is manifestly attended with malafide, and where the proceeding is maliciously instituted with an ulterior motive for breaking vengeance on the accused and with a view to spite him due to private or personal grudge. In such case, there should be evidence that there is a previous enmity, there is a previous dispute, there is civil dispute or any other dispute, or any proceedings which are initiated by the accused, or that the other side he has lost in election against the accused. If you are having such grounds, so even on such grounds, those will be one of the aspect which will be there on the basis of which you will file application for quashing of the proceeding. But only on the ground of enmity, only on the ground of any previous grudge, the proceedings will not be quashed. That will be one of the ground which will be there, that will be helpful in order to show that the proceedings are being filed on the basis of the malafides. Even for example, in a case wherein a complaint is filed previously, an application is filed with the police. In that application, there are no allegations of a cognizable offense. Then subsequently, after 10 days, you are adding allegations in order to make it cognizable, and then along with it there is a dispute. So in such type of cases, you can make out a case that initially when the FIR was filed or the complaint was filed, at that time these allegations were not there. Subsequently, these allegations they are added only in order to make out a case, and therefore in such case even you can move an application for quashing. One thing should be remembered when you are filing an application for quashing of FIR or quashing of proceeding, the defense of the accused, that is never entertained. If you are having a plea of LEB, if the plea of LEB is being investigated by the police themselves, and if they come to a conclusion that you are not there, they will file a final report against you. But there is no investigation on that line. If you are claiming that you are having a plea of LEB, then the court says that this is required to be proved by you, and therefore when you are filing a quashing of application or proceeding, that is not a stage wherein the evidence should be led. So in cases wherein if you are having a documentary evidence, you are having a defense, you will have to lead defense, and the proper stage is the trial. That cannot be entertained in quashing application at time of quashing of the proceedings. There are cases wherein, for example, if any variance is there in the statements, if there are different witnesses who are giving different version to the incident, if there are multiple dying declarations, even in such cases, you can't file an application for quashing. Those proceedings cannot be quashed. In one dying declaration, the deceased has given a statement that I burned accidentally. In second, subsequently, after delay of 1 or 2 days, a statement is there that I am burned. So and so accused caught hold of me, another accused poured kerosene, someone set on fire. Though there are inconsistencies in this dying declaration, but those will be subjected to scrutiny at time of the trial. On that basis, you can't file an application for quashing. So you should know that in which cases you can proceed with quashing, and in which cases you should not file application. So in such cases wherein you can file an application, generally the first thing which you should even ask for yourself, that we will take the entire allegations, we will read the FIR. Even if the client is there who is asking for that we want to file an application for quashing, that these are the allegations, so and so allegations are there against you. If these entire allegations are accepted, okay, there are two, whether it is making out a case. If the answer is yes, then there is no point in filing application for quashing. Then you should proceed with the trial. But if the answer is that no, even if you accept and it is not making, then you can proceed. So this is the checking how in which matters you can file application, in which matters you should not file. For that, this is for your check. That this question should be asked to you yourself, that whether it is making out a case or not, and then this all other grounds are there. Even there may be a case wherein FIR is against the accused under section 326 of IPC. That is the only non-bailable, that is the only cognizable offense which is there. The rest of all the sections, they are non-cognizable. And if the injury which is caused, that is simple, then you can move an application for quashing. That the requirement for 326 IPC is that there should be a grievous hurt. If the injury is simple injury, then there is no point in proceeding. The other sections, they are all non-cognizable, and therefore the proceedings should be quashed. So this, in such type of cases, even we come across that applications are filed, even those can be there, wherein offenses under allegations are there of rape, that accused subjected to sexual relations on the promise of marriage. If you are having a case that you were really, there is an evidence that the accused was really in love with the victim, that went on for much period, Then subsequently, they both were even conscious, knowing that there may be hurdles in their marriage. But then also they both proceeded, they had relations, and subsequently, for one reason or another, if he is not able to proceed for marriage, then that just because of that, it will not be a case against him under for 376. So if you are able to demonstrate on the basis of the available evidence which is there on record, the investigating officer, he has seized the mobile, the messages are there, the chits are there, letters are there. So if on that basis you can make out the case that it was consensual relation and there is no element of any cheating or promise of marriage or relation was not on that ground, then in that circumstance you can proceed. There may be a case wherein the accused is married and this is known to the victim, this is known to the informant, and then also she claims that there was a promise of marriage, that when he is married, he can't marry during the lifetime of the first, and therefore she was also knowing it that marriage is legally not possible. So in such type of cases, when she is major, she has taken the decision to have relations and she was that much competent. And such type of cases, you can move an application that even if you accept the entire allegation, it is not making out a case of rape, and therefore the proceedings should be quashed or the FIR should be quashed. There is no such grounds which are there. Whatever your case is there, you have to mention on the basis of those the grounds which are there as per the allegations which are there, and then the prayer. This is how the quashing applications, quashing proceedings, they are drafted. It is again one thing, procedure when bill is allowed. The practically when the bail application is allowed, if the bail application is allowed by the High Court, we have to take the order before the concerned court before whom the surety is to be furnished. The bail bond, two bonds, one is a personal bond and one is a surety bond. We have to mention all the particulars which are mentioned in the form. The surety which he is giving, if it is 712 extract, the particulars of the 712 extract. If it is solvency, details of the solvency certificate. The conditions which are put to the accused, those should be mentioned on the personal bond, PR bond, because that is forwarded along with the release order in jail, wherein accused is required to sign over there. So accused should know that what are the conditions which are imposed by the court against him. Those are to be mentioned on the PR bond, and then the release order is to be taken and sent. This is the procedure for filing the surety after bail is, if the bail is granted. If any questions are there.
Thank you so much, sir. I think we do not have any questions in the chat box. And we understand how precious your time is, and still you took out time to and addressed our participants. Thanks would be a small word for this. We respect your time, sir, and hence I would like to conclude this session with your permission.
Okay.
I express my deepest sense of gratitude to Mr. Nilesh S. Ghanekar, sir, for this wonderful session. His profound insights have left us inspired and enlightened. We are grateful for the depth of knowledge he shared with us today, and we look forward to applying these valuable insights in our own legal journey. Thank you so much, sir, once again, for giving your valuable time to us and for enlightening everyone with your insights. We are extremely honored to have you on this platform. I also would like to thank all the participants for being cooperative during the session. We'll meet tomorrow at the same